The hat is back, and today it's all about motions to reconsider. Now, these are sometimes called the poor man's appeal. It's where, in lieu of paying a lot of money for an expensive appellate lawyer, you can ask your judge to reconsider the applicable judgment because of, let's say, changes to the law, new evidence, or as in today's case, the court misapplied the law. Now, before my non-lawyer audience gets a little too excited, unlike an appeal which goes before a different panel of justices, a motion to reconsider stays with the trial judge who handled the case. And unlike an appeal, it applies in a far more limited number of circumstances. You can check out my video for examples. I've included a link or two below for other times that I've covered motions to reconsider. Now, a watered-down example of misapplication of the law might be a judge who granted a child support modification retroactive to the date of filing. But let's say it turns out the petition, for whatever reason, wasn't served on the other side until, let's say, a year later, and the statute limits relief to the date it was served out, not the date of filing. So if you bring it to the judge's attention, it's an easy fix, and you saved your client some money there. But what if the motion to reconsider exaggerates what happened at trial and the judge relied on it? Would it surprise you if I said that up until now, there's been no case law on this? So if you're curious to know the answer, stay tuned. Hello again, hope you're all doing well. As always, pandering moment. YouTube doesn't pay me, but the likes and subscribes help me gauge which videos and cases to cover in the future. And before I start, I gotta do this. Longtime viewers understand I try a lot of things, like this homage to Star Wars or this one from the Terminator franchise. Not everyone who follows this channel are lawyers. I'm just trying to make the subject matter accessible to everyone. If you see me do anything like what you're about to see at the conclusion of this broadcast, it's not me being discourteous. If I kid, my aim is to do it in a respectful manner because as lawyers and judges, we all have the same goal, to understand how the law works and to apply it correctly. Okay, moving on to today's case, which comes from juvenile court. It's a wardship proceeding. Don't worry if you don't concentrate in neglect cases. I'm going to keep it light. But before I dive into it, shout out to Marv Raidbard, who was appellant's counsel in this case. Now, Marv has been a long-time appellate lawyer and is the cornerstone to Cook County's appellate panel for neglect and abuse cases. These are always tough appeals to handle. But spoiler alert, the little guy comes out on top today. So long story short, the state wants to take custody because there's marks on an infant. At trial, both the state and the parents bring in their own experts to argue how they got there. From a, global view, the more qualified experts were unable to opine that the marks came from abuse. It might have been from a recall pack and play or a pre-existing medical condition. The trial judge initially rules the state failed to meet its burden and dismisses the case. The OPG, who serves as GAL in most of the JV cases in Cook County, files an emergency motion to reconsider. It's granted and the state takes possession. The parents appeal. And this is where I'm going to stick really close to the opinion. From the appellate court's perspective, they felt both the OPG and the state at the emergency hearing on the motion to reconsider were recasting the expert testimony and that, quote, the representations made by the public guardian and the state that all medical causes were ruled out simply does not track with the expert testimony given in this case, end quote. So the wardship is reversed and the takeaway here, motions to reconsider stating the court misapplied the law cannot recast or incorrectly represent testimony or exhibits presented at trial. Kind of a no-brainer, right? And if it appears a judge relies on it, that's going to be a basis for reversal. Before I go, Judge Regina Scanicio was crowned the new chief judge of the Domestic Relations Division in Cook County. Longtime followers may recall I covered a few of her cases here on this channel. She has a near perfect appellate record. So, congratulations to the new Queen of the North.